suggest had acted as an intermediary for Mr. Sheikh in eliciting funds from another of the SDPP contracts. A further allegation is that Thomson CSF, a French arms manufacturer, was awarded a contract for the supply of combat systems to the SA Navy. It was suggested that Mr. Sheikh had instructed Thomson CSF to ensure that the South African company through which it operated, that is, African Defence Systems, should be jointly owned by Thomson CSF and Kobe Holdings, which was owned by the brother of Mr. Sheikh, namely Mr. Shabir Sheikh. There was evidence which suggested that Thomson CSF were convinced of the need to include Nkobi Holdings as a shareholder in African development systems after the direct intervention of both former President Jacob Zuma and Mr. Chippy Sheikh. In Mr. Butlender's view, all of these allegations were sufficiently serious to require thorough investigation and careful questioning from the Commission. Mr. Butlander pointed out that in his evidence in chief, Mr. Sheikh was silent regarding any allegations of corruption made against him, and that when he was examined by the evidence leader, Advocate Silo, none of the documents to which reference has been made and which supported allegations of corruption against him were put to him. Advocate Silo asked no more than extremely generalized questions. Mr. Butlander therefore submitted that in relation to Mr. Sheikh and the multiple allegations of corruption involving him, only the most general questions were put, all of which did no more than to provide Mr. Sheikh with an opportunity to make a general denial. Advocate Fana Hlongwane. Advocate Hlongwane was also a very important witness. It is apparent from the record in the possession of the Commission that he had been accused of corruption relating to the conclusion of certain SDPP contracts. He had been the subject of two related investigations by the Scorpions and the Asset Forfeiture Unit. Advocate Hlongwane had entered into both overt and covert arrangements with BAE Systems to receive funds in relation to the Hawk and Gripen aircraft contract concluded through the SDPP. The overt arrangements comprised of consulting agreements, two of which were between Hlongwane Consulting and BAE Systems on 9 September 2003, and another between Hlongwane Consulting and SANIP, a BAE-controlled South African entity, which commenced on 1 August 2003. The allegation is that Hlongwane Consulting received over £10 million by way of the first consultancy agreement between September 2003 and January 2007, and over 51 million rands by way of a second consultancy. Mr. Mavi concluded his report thus: BAE have not provided the SFO with any written report to justify the size of these payments. According to the SFO, further payments were also made to Advocate Hlongwane, being approximately 60 million rands by way of Astor Commercial Corporation, a company considered or registered in the British Virgin Islands and controlled by one Alexander Roberts. Astor received approximately 15 million pounds from Red Diamond and had then paid over 5 million pounds to Advocate Hlongwane. The affidavit of Mr. Murphy concluded thus, and I quote him: I believe that the varied ways in which Fana Hlongwane has received payment in relation to the Hawk Gripen contract is highly suspicious. BAE operated a covert method of payment through the Red Diamond systems. However, it appears that even this system was insufficiently opaque to disguise payments to Fana Hlongwane. Close quote. These allegations were supported by a further affidavit deposed to by a senior special investigator, Advocate Johan Duploy, employed by the Directorate of Special Operations, DSO, in support of an application for search warrants in terms of Section 29 of the National Prosecuting Authority Act against Advocate Hlongwane and Mr. John Bredenkamp. In this affidavit, the following allegations are made, and I quote them. In the light of the witness and documentary evidence that has been obtained thus far by the SFO and DSO, I am of the opinion that there exists a reasonable suspicion that specified offences have been or are being committed. There is, at the very least, a reasonable suspicion that Fana Hlongwane and or Hlongwane Consulting and others to influence him to misuse his position to benefit the grouping or to reward him for having done so. BAE have paid very large amounts of money, approximately £103 million or 1.5 billion rands to a number of consultant advisors under the South African Hawk Gripen campaign and have provided the SFO with utmost no written evidence explaining the nature of the services provided by these consultant advisors, including work done by Fana Hlongwane and or Hlongwane Consulting and Ongwane Aerospace and or Trevor Wilmans. I believe that the varied ways in which Fana Hlongwane has received payments in relation to the Hawk Gripen contract is highly suspicious. If his relationship with BAE was a legitimate one, I can see no reason why BAE did not pay in all monies directly. I close quote. Further evidence which implicated Advocate Hlongwane emanated from the National Prosecuting Authority. This evidence was sourced in proceedings regarding the seizure of funds controlled by Advocate Fana Hlongwane in Liechtenstein. In his oral testimony to the Commission, Advocate Hlongwane was asked only a single question regarding these allegations, to which he responded in broad generality without referring to any specific document, allegation, or evidence. The Commission itself failed to put one question to him, and he was neither re-examined nor cross-examined. He was not confronted with any of the evidence to which we have made reference, all of which was available to the Commission. Mr. Budlander submitted that the Commission had failed to test this critical evidence of a most important witness against whom a series of detailed allegations of corruption had been made, all of which went to the heart of that which the Commission was enjoined to investigate fully and with an open mind. I come to the Debevoise and Plimpton report. The Commission had come into possession of a report by the U.S. law firm Debevoise and Plimpton, the DP report, of April 2011, which had been compiled by Debevoise and Plimpton for its client Ferrostar. It is common cause that this report was in the public domain. Nonetheless, the Commission refused to admit it on the grounds that it was placed in the public domain stealthily without the consent of Ferrostal, and Ferrostal had not waived its right of professional privilege. Ferrostal was a company that formed part of the German submarine consortium, which was awarded a contract to supply the South African Navy with 3 submarines in terms of the SDPP. The particular focus of the report was on whether Ferrostal had engaged in corruption or other wrongdoing in conducting its business. This investigation included Ferrostal's role in the SDPP. The Commission stated that the DP report was made available to us on a confidential basis for the purpose of assisting us in our investigations, and for that reason we have perused it. I close the quote. However, Mr. Budlander submitted that the Commission did not explain how the report had been made available on a confidential basis, or how the Commission could accept the document on this basis, consider its contents, describe and address the contents in its report, while at the same time insisting that it not be admitted into evidence. In Mr. Budlander's view, the approach of the Commission to the DP report was fundamentally flawed when examined against established South African law regarding privilege. Mr. Budlander submitted further that a reading of the report revealed that the conclusion of the Commission to the effect that had the DP report been admitted, it would not materially have altered the findings of the Commission, because its investigation and ultimately its findings had revealed no evidence of bribery, fraud, or corruption in the SDPP was totally incorrect. Mr. Budlander submitted that in the light of the contents of this report, it was inexplicable that the Commission had neither subpoenaed, interviewed, nor questioned any of the individuals implicated in this report. He argued that the Commission failed to seek from Ferrostyle or Debevoise and Plimpton any material that formed the evidentiary basis for this report. I come to the draft Auditor General reports. The Auditor General initially produced draft reports on the SDPP. Unlike the final report, these reports pointed to major procurement irregularities across the entire SDPP process, as well as numerous allegations of corruption which were relevant to the Commission's remit. The Commission considered that the draft reports were inadmissible, although they contained material of significant importance, which was not contained in the final report. The Commission refused to admit the final draft report on the basis that the second respondent was not sure whether the draft report made available to it was the final draft version. Notwithstanding, argued Mr. Budlander, that the record showed that the Commission had been given the final version of the draft report and that the Auditor General had given permission to provide this report to witnesses who wished to rely upon it on condition that they took an oath of secrecy for national security reasons. I come to relevant records of criminal proceedings. The Commission refused to take account of the record of the proceedings in the State versus Shabir Sheikh case. It is difficult to divine precisely the reason as to why the Commission failed to consider this record and findings of the court in this case, as well as the criminal proceedings brought against former President Zuma in the case of State versus Jacob Zuma, Tint Holdings, and another. In short, argued Mr. Budlander, Mr. Shabir Sheikh was found guilty of soliciting from Thomson CSF a payment of $500,000 per year for the benefit of former President Zuma until the payment of the first dividends owing to African defense systems. In return, former President Zuma would protect Thomson CSF from investigations into the SDPP and support and promote its business interest in the country. These were, according to Mr. Budlander, clearly issues which were central to the Commission's mandate, but it inexplicably, indeed irrationally, eschewed any interest in examining the trial record and its implications for its inquiry into the SDPP. Our evaluation: it bears re-emphasis that this case does not concern the merits of the SDPP, nor the veracity of any allegation of corruption or wrongdoing pursuant thereto. This court is only required to determine whether the Commission, in undertaking its task, failed to comply with the requirements of legality and rationality, which are the tests to be applied in respect of an application to review the Commission's findings. Again, we reiterate that the factual matrix set out by the applicants is uncontested and thus has to be taken as the factual basis upon which the decision to review and set aside the Commission's findings is predicated. To return to the law relating to the powers of this court to review the Commission's findings, while no individual party's rights were detrimentally affected or determined detrimentally as a result of the findings of the Commission, the latter operated manifestly in the public interest. The Commission was granted extensive powers, public powers through the Commissions Act, in order to investigate and make recommendations on a matter of major public importance, so as to bring finality to a controversy which had bedeviled South Africa almost from the dawn of democracy. A significant amount of 137 million rands of taxpayers' money was spent in order for the Commission to complete its mandate. In the exercise of its functions, the Commission had to act within the confines of legality. It could not, for example, perform its tasks by demonstrating bias, breach fundamental principles of fairness, or commit significant errors of law, such as refusing to admit evidence on manifestly incorrect legal grounds. In the present case, Even on the basis of the limited set of examples contained in this judgment, it is clear that the Commission failed to inquire fully and comprehensively into the issues which it was required to investigate on the basis of its terms of reference. This is evident from the failure to examine the DP report or the evidence which emerged from the Shabir Sheikh trial, which it refused to admit and thus consider evidence which was highly material to its inquiry. All this evidence was in its possession. The manner in which the evidence leaders and members of the Commission approached critical witnesses, particularly Mr. Chippy Sheikh and Advocate Hlongwane, exhibited a complete failure to rigorously test the versions of these witnesses by putting questions to them with the required open and inquiring mind. Given the wealth of allegations contained in material in the possession of the Commission against them, it failed to confront these witnesses with these serious allegations which were made against both in respect of corruption and wrongdoing. The questions posed to these individuals in particular were hardly the questions of an evidence leader seeking to test extremely serious allegations that went to the heart of the reason for the establishment of the Commission. Additionally, other than being influenced by the alleged lack of authenticity of the documents on which the allegations against Mr. Sheikh were based, the Commission seems to have been content to simply put the allegations to Mr. Sheikh and then to accept his denial thereof. This is hardly an investigation whose objective is to get to the bottom of the allegations. It cannot be the modus operandi of an independent commission determined to discharge its mandate to ask peripheral questions to implicated witnesses and thus fail to test the veracity of the evidence in terms of documents, reports, and records which were readily available to it. The Commission also accepted the evidence of Mr. Sheikh without demur regarding allegations of bribes made by Bell Helicopters, the alleged instruction to Thomson CSF to ensure that African Defence Systems would be partially owned by Nkobi Holdings, which in turn was owned by his brother, Shabir Sheikh. Advocate Hlongwane was treated even more generously in that no questions were put to him by the Commission, notwithstanding the damning SFO affidavit and the further affidavits from the DSO and NPA with regard to search and seizure application of Advocate Hlongwane's premises and preservation. Advocate Hlongwane filed a statement with the Commission. The statement filed by Advocate Hlongwane with the Commission contains general denials of any wrongdoing on his part or by any of his companies. In our view, an examination of Advocate Hlongwane's witness statement called for further investigation. For example, he stated that his relationship with BAE Systems began in 2003 by way of an agreement between Hlongwane Consulting and SANEP. This was contradicted by the SFO affidavit, which claimed that the relationship began at least by late 1999. His witness statement made no mention of the second overt consultancy agreement in Hlongwane Consulting and BAE Systems of 9 September 2003, backdated to January 2002. It must be pointed out that nowhere in the statement does Advocate Hlongwane deal with BAE's web of companies with which he and his companies conducted their dealings, as well as the payments detailed above that flowed into his company's coffers. In addition, nowhere does Advocate Hlongwane explain what services he and his companies rendered to BAE to justify the significant amounts of money that were channeled to his companies by BAE through its web of companies. The Commission did not inquire into these issues, despite the damning allegations in the affidavits of Murphy, Duploy, and Downer. Similar allegations are also contained in the Auditor General's draft report, which the Commission paid no attention to whatsoever. There was no attempt to confront Advocate Hlongwane with that which had been alleged in the SFO affidavit, namely that Hlongwane Consulting had been paid more than £10 million between September 2003 and January 2007, or how the agreement had been varied on 5 September 2005, and I quote, to allow for a an $8 million ex gratia payment in full and final settlement of all additional work regarding grip and tranche. The Hlongwane witness statement was equally silent on the approximately 60 million rands transferred to him from Astor Commercial. A commission which was intent on inquiring and thus determining the truth could not have accepted this witness statement without careful interrogation. However, when Advocate Hlongwane testified, there was only one occasion on which he was probed with regard to matters outside of his witness. The evidence leader, Advocate Mpacha, asked Advocate Hlongwane about the joint submission which had been made by Mr. Andrew Feinstein and Mr. Paul Holden, both of whom had written books about the SDPP. Part of Advocate Hlongwane's response is, and I quote him, "So maybe the commission will assist me. Why is it an issue, as I asked the question before? There are many other people who received greater quantums. Why is there a problem in our case? I have a small problem there, but I'm sure that the commissioners, they will be able to tell me what is it that I must tell my children. Have I ventured into sacred holy land that I'm not supposed to go into? Is this a mechanism to say that you must not venture into that area again to be taught a lesson? Did I go through without a visa into the state that is reserved for others? Because when you begin to look at the issues with respect to the commissioners, and I've got the greatest of respect for the commissioners and the way they do it, but the fundamental question to me is no evidence had been laid about my influence or doing anything untoward. If no evidence had been laid, again, I say it with respect, I am here now, say, yes, 1.5 does not apply to me, but if the issues is quantum, then my fellow consultants should be here with me, canvassed by the same major." I closed the quotation. Advocate Hlongwane was then permitted to ramble on about all manner of complaints about the motivations for the allegations against him, which had little to do with the terms of reference of the commission, nor did he address any of the allegations leveled against him. The evidence leaders failed to ask any questions with regard to the specific pieces of the evidence which were available to the commission, nor was any single question put to Advocate Hlongwane by members of the commission. In short, there was a manifest failure to probe any of the manifold allegations against Advocate Hlongwane, notwithstanding the supporting evidence available to the commission. The commission accepted as common cause evidence that former President Thabo Mbeki, then Deputy President of South Africa, had played no part in the awarding of subcontracts to Thomson CSF, despite evidence of an encrypted fax which implicated him in the awarding of the Thomson CSF contract. In this connection, there was evidence from Dr. Richard Young, who had referred to oral evidence of Pierre Moyot during the Shabir Sheikh trial, where the latter had testified that Thomson CSF and African Defence Systems had actively sought political backing at the highest political levels. Dr. Young referred to the encrypted fax where Moyot claimed that former President Mbeki had given his assurance that Thomson CSF would be awarded the contract for the combat suit and sensors. To this end, the second respondent, that is the chairman of the commission, said, "We have never heard any evidence from all the witnesses of AMSCO and the DOD who ever said that former President Mbeki gave instructions to do A, B, C, and D. That is why I'm calling it a field theory, which is not based on any facts, because all these witnesses, none of them came out with that theory. You are the one who comes up with the theory. Now you say to us, he could have influenced the awarding of the subsistence. I find that a bit strange." I close quote. This passage reveals an approach which ran through the proceedings of the commission, namely that second respondent, as the chair, who was the chairperson of the commission, adopted the position that the evidence given by what were referred to as non-critical witnesses were known facts, and evidence given by critical witnesses such as Dr. Young were merely theories. Manifestly, implicated witnesses would hardly suggest any wrongdoing which had been perpetrated by them. Their evidence had to be treated cautiously and subjected to rigorous scrutiny, for that was effectively what the role of the Commission was intended to achieve in order to arrive at an accurate set of findings. But it is evident in the record of the Commission, for example, of its approach to Mr. Chippy Sheikh and Advocate Hlongwane, when it came to implicated witnesses, the Commission became supine. Mr. Budlander further submitted that the Commission failed to access information that was highly relevant to its work. This was a reference to the Commission's refusal to initiate diplomatic processes to access information held by the German, Swiss, Swedish, the West Indies, and Liberian authorities. This submission is based on uncontested allegations by the applicants who have demonstrated the relevance of the information held by these authorities. The failure of the Commission to access this information, relevant as it was to the issues it was enjoined to investigate, seriously hobbled its investigation. It is a failure that effectively deprived the Commission of the essence of the investigation it was established to undertake, coupled with a myriad other issues that the Commission failed to inquire into, such as the allegations contained in the SFO documents, the settlement between BAE and the U.S. Department of State, as well as the matters involving Ms. Zuleika Mohammed. We are fortified in our view that the inquiry and investigation that the Commission was called upon to undertake never materialized. The constitutional principle of legality operates as a much-needed safety net for exercises of public power that do not amount to administrative action. The principle of legality and its underlying source, the rule of law, dictate that there must be a rational relationship between the exercise of a public power and the objectives for which it is exercised. In this case, the objects were to investigate with an open mind in order to reveal the truth to the public on a matter of the utmost public importance, one, as we have indicated, which had bedeviled the constitutional democracy in this country since its dawn. Based on the uncontested evidence presented to this court, the Commission failed manifestly to inquire into key issues, as is to be expected of a reasonable commission. It refused to admit critical reports, such as the DP report, at best for it on the basis of a clearly inaccurate understanding of the law of privilege. It accepted facts as common cause when a reasonable commission would have probed the evidence in order to test the veracity of the evidence from what were referred to as non-critical witnesses. It refused to examine the proceedings of the Shabir Sheikh trial on the inexplicable basis that somehow the record of that trial was not relevant to the fundamental nature of the Commission's inquiry. At best for the Commission, it failed to appreciate that the rules of evidence and procedure of a Commission are considerably less strict than those of a court. Whereas a court of law is bound by the rules of evidence and pleadings, a Commission is not so bound. It may inform itself of facts in any way it pleases, including the hearsay evidence, newspaper reports, or representations or submissions without sworn evidence. Commissions are designed to allow an investigation which goes beyond what might be permitted in a court. We accept that courts must be cautious before exercising a power of review over the proceedings of a commission. To exercise the review power in an overzealous fashion would be to subvert the flexible nature of a commission's choice of procedure and constrain many decisions that a commission must make along the way to its ultimate findings. However, where the uncontested evidence reveals so manifest a set of errors of law, a clear failure to test evidence of key witnesses, a refusal to take account of documentary evidence which contained the most serious allegations which were relevant to its inquiry, the principle of legality dictates only one conclusion, that the findings of such a commission must be set aside. Costs. Mr. Butlander submitted that as this application had been opposed by the 4th, 5th, 6th, and 7th respondents, albeit that they withdrew their opposition when the time came for them to file answering affidavits, justified an order of costs in favor of the applicants. He contended that the initial opposition from the respondents was sufficient to justify such an award. In our view, an award of costs can be justified in this dispute until such time as the respondents withdrew their opposition to the relief sought. Accordingly, the following order is made. The findings of first respondent issued and published in a report released to the fifth respondent on 30 December 2015 and made available to the public on 21 April 2016 are hereby reviewed and set aside. Fourth, fifth, sixth, and seventh respondents are ordered to pay the costs of the applicants, including the cost of 3 counsel, which were incurred until the withdrawal of the 4th to 7th respondents of their opposition to the application. I hand down the judgment. Okay?
I agree.
I agree.
Sorry, I should have hand down this as well. Yeah, that's fine. Court adjourns.
She just wants to